Estate planning isn't just about what happens to your money when you're gone. Estate planning, remember, is defined as the process of accumulating, protecting, and ultimately distributing your wealth. As our regular viewers know, we talk a lot on the show about the importance of protecting your wealth from Wall Street and from the kinds of extreme market downturns and volatility that we've seen since the turn of the century. But when it comes to estate planning, protecting your money from things like market losses and erosion of principal is only just part of the equation. There are many other potential threats, as I've discussed before, related mainly to legal fees, taxes, and medical costs. So let's talk about those one by one, starting with avoiding unnecessary legal fees. Basically, the more that your estate has to go through the legal system after you die, the more costly that process is going to be. Most people know that if you die without a will, your assets go through probate. But what many don't realize is that if your assets pass to your heirs via a will, there is still no avoiding probate or probate fees. In fact, the word probate comes from the Latin word probare, which means to prove. The probate process is intended to prove the legitimacy of the will that's being presented. How do courts do this? Well, by making a list of all your assets available to the public. Now, this carries a risk of more expense. Why? Because when your assets become public information, it means that anyone can look at them and go to the court and say, "Judge, I've got a claim." Or say, "Judge, I've got a copy of a last will and testament that says that this money belongs to me." At that point, the judge has to consider the claim or decide which final will and testament is actually the last one. And there may be other claimants arguing against it also. So in addition to the expense, probate can actually tie your assets up for a long time if you have not taken steps to minimize or avoid the probate process itself. Perhaps the most comprehensive way to avoid probate is to have something called a living trust to pass your assets on. You can have this instead of a will, and I'll talk more about this later. But there are other strategies for minimizing your will's exposure to probate and all the probate fees involved. As a general rule, any asset that has a beneficiary designation can avoid probate. Qualified plans such as IRAs, pensions, and 401ks can all avoid probate if you've designated human beneficiaries. Now, the same goes for things like life insurance, annuities, and jointly held property, and even some non-retirement accounts where you've designated a beneficiary through what's known as a TOD or a POD, a transfer on death or payable on death designation. Those beneficiary strategies are all ways of shielding specific assets from probate without having a living trust. Now, what's even better is that by designating human primary and secondary beneficiaries on your retirement assets, it can also help you when it comes to guarding against the second major financial threat to your estate plan: excessive and unnecessary taxes. Of course, there are two different kinds of taxes you have to think about in your estate plan, which are estate taxes and income taxes. The good news when it comes to estate taxes is that the rule changed at the federal level 3 years ago in a way that exempts most people from owing anything. Federal estate taxes, or death taxes, today start at estates worth more than $5.3 million of assets. If you're married, then they only kick in at double that amount, which is $10.6 million of assets. The bad news is that if you're over that threshold, the tax rate is 35%. And unfortunately, most states have not followed Uncle Sam's lead to raise their own thresholds. Estate taxes in certain states can kick in as low as $1 million of assets. As for income taxes, those can impact you regardless of your net worth. And the last thing you probably want for your loved ones is to inherit a major tax burden when they get your assets. But again, there are proactive steps that you can take to avoid that. One of which is designated human and primary and secondary beneficiaries. As you may know, a spouse who inherits an IRA or 401k can defer the taxes on that money through much of his or her lifetime. But that doesn't apply to children who inherit these accounts. The exception is if they are named as beneficiaries. In those cases, they can keep an IRA intact and they could pay taxes in tiny little bits and pieces over time, in essence, deferring those income taxes. So identifying human beneficiaries on your assets, especially your IRAs, is clearly a key strategy for avoiding financial pitfalls. But there are two important things to remember. First, some of the things that you put a beneficiary designation on can overrule and override what you say in your will. For example, if you have a beneficiary on your IRA that says everything goes to my daughter, but your will says that half of it is supposed to go to your son, guess where the IRA goes? To your daughter. Again, the beneficiary designation supersedes the will. Second, designated beneficiary is not the same as putting an asset in a child's name. That's actually something you probably never want to do. In an ideal world, it might be fine, but let's face it, life can get messy, as we all know. And if the child in question gets divorced, for example, then half of that asset can go to their ex-spouse. Or if they get sued, it's subject to collection by whomever is suing them. I've seen it happen. A lot of heartache and a lot of loss can result from this one single mistake. Now, also remember that it's important to identify all your beneficiaries, primary and secondary beneficiaries, because so many different scenarios can occur. Let's say, for example, that you name your spouse as a beneficiary, and that's it, no second or contingent beneficiaries. The two of you get killed in a car accident together. If you don't have these secondary beneficiaries, now the thing you thought was going to avoid probate is going to get pushed right back into probate. Or, let's say, for example, that your son is primary beneficiary, and you have to consider the possibility that you get into an accident with your son, or the worst case scenario, that your son predeceases you, something that, as we all know, should really never ever happen. But are you going to be in the right frame of mind to pick up the phone after losing your son, call your financial advisor and say, hey, I need to change my beneficiary? Probably not. So that now gets into a very important aspect of beneficiary designations, which most people are not aware of. In fact, most people haven't heard of it. And this is an important distinction between what's called per capita and per stirpes designations. This is something that again, many financial advisors aren't even aware of. And they end up unwittingly putting the wrong designations on your accounts because they don't know the difference. This is so important that I'm going to talk more about this in the news and views section of the show. I'll also talk about some of the other reasons, other than avoiding probate, that someone might want to have a living trust rather than a will. In short, the main reason for having any kind of trust is typically that you want to have the ability to control your assets from the grave, as I'll explain in a moment. But right now, I want to cover that third major financial threat that you need to protect against in your estate planning. And that is the medically related threat and the possibility that your deteriorating health or cognitive function and the associated healthcare costs can deplete assets that you want to leave behind. Now, this is exactly why a good estate plan needs to include clear instructions for whom you want to make financial and healthcare decisions on your behalf if you're no longer healthy enough to make them yourself. These instructions generally come in the form of a durable power of attorney and designation of healthcare agent. The first designates whom you want to make financial decisions, and the second, of course, designates whom you want to make healthcare decisions. Closely tied to that is something called your living will, which specifies your own wishes for end-of-life medical care. I tell a story often in my estate planning workshops about a client of mine whose father was on life support. And he realized they were at the point where his father would have wanted to pull the plug. So he went to the doctor. Initially, the doctor said, I'm sorry, we can't do it. Fortunately, the son was able to go and get his father's living will from a safety deposit box, come back and show it to the doctor. And with that, they're able to fulfill his father's final wishes. The objective behind all of these provisions is to help protect your money from costly mistakes that you might make if your decision-making abilities deteriorate, and from the potential of financial drain of extreme, ongoing, prolonged healthcare costs. Because again, estate planning is not just about how your assets are distributed after you die, it's about how you manage, protect, and preserve them long term. And while the prospect of confronting and thinking about some of these issues may not be pleasant for most people, in the end, you risk a lot more of potential pain and discomfort by procrastinating or trying to avoid this altogether.